I think we'll turn it over to you and your background, unless you're going to say anything else, and talk about whatever you're going to talk about.
Okay, great. So as Bob said, I used to be a practicing lawyer in Los Angeles, and then now I'm a rabbi. I should say a little bit about, I'm going to talk a little about Jewish law and its relationship perhaps to American law in a couple of ways. But before I do that, I should probably tell you a little about myself so you know the point of view that I'm going to be describing things as. So just as in the Christian world, there are different denominations of Christianity with a lot of different opinions and churches, and in Islam there are different sects and cultural interpretations of Islam. In the Jewish world, we have different denominations also. So I'm going to somewhat unfairly generalize the categories. The sort of more fundamentalist Jews are Orthodox Jews. They sort of are more fundamentalist in their interpretation of the Bible and how they understand science. And then there's the liberal reform movement at the other end of the spectrum, which is less observant of rituals and much more liberal in interpretation of Jewish tradition. And then there's the conservative movement, which is in the middle. It's not conservative politically, but we call ourselves conservative. I'm a conservative rabbi because historically we were a breakaway from those radical reformers. Right, so the reform movement broke away from orthodoxy, and then what happened was they got too liberal, and a group of Jews said, "Hey, you threw the baby out with the bathwater. We're going to conserve Jewish traditions," and so we broke away from those radical reformers. That all happened in the 1800s, and in modern-day Judaism, the reform movement has largely found its way a little more back towards the center. And our movement, the conservative movement, is probably inched a little bit more to the liberal end. But basically what you have is sort of a spectrum of Jewish approach with ultra-Orthodox kind of in the ultra-fundamentalist and the liberal reform at the other end, and sort of an array of Jews in the middle. So I'm coming from a middle centrist perspective, but I'm not Orthodox. Okay, so the first thing to know about Judaism and Jewish law is that it's not strictly based on the Bible. In fact, Judaism never really had a sort of a fundamentalist approach to the Bible. We've always, at least as Judaism developed, have understood that the Bible had to be interpreted and that there was a long tradition of oral interpretation of the Bible that went on for generations and generations. Some would say back to the time of Moses. And that in order to really understand how we're supposed to practice our faith, you need to understand how it was orally interpreted. And I'm going to give you some examples of that in a minute. The people who carried that tradition, interestingly, were the Pharisees, who I understand do not get good press in the New Testament. However, that's the Pharisaic movement, just so you know, were the Jews who believed in an afterlife and believed in resurrection of the dead. The other major party at the time of Jesus, for instance, was the Sadducees party. The Sadducees was a party of the priests. They did not believe that there was any life after death, that this was all there was to life. And in other ways, this is not the forum for this conversation, but in other ways, I think that Jesus is much more aligned with the Pharisaic movement than the Sadducees or any of the other movements that were around at the time. But the Pharisees, after the temple is destroyed, sort of morph into the rabbis of the Talmudic era, and they continue this process of oral interpretation of the law, and that ends up being codified first in a book called the Mishnah, which was codified in the year 200. The Jewish law in the Mishnah is divided into 6 categories, 6 major topics. Each category is subdivided into subcategories, and each subcategory gets its own tractate, which is then divided into chapters and then separate rules. Right? So that's the structure of the Mishnah. When it is published in the year 200, I say published, of course there wasn't a printing press, so published meant somebody hand wrote a copy and then it was memorized by memorizers. And then that text was studied in the academies for the next 300 and something years and argued over, but Jews love to argue, So it was every single word was argued over, and those discussions and arguments were then finally written down in something called the Talmud, which was published in the year 550 or so. Okay? Every single page of the Talmud has arguments on it. Very few conclusions, just so you know. We like to argue, we don't like to make decisions. So why is it important to understand that? So I'll give you a classic example. So in the Bible it says, if two people are fighting and one guy pokes out another guy's eye, then the Bible says the penalty is an eye for an eye. If he pokes out a tooth, it's a tooth for a tooth, right? Hand for hand, foot for foot. That's what the Bible says. So as one Jewish genius once wrote, well, if we really followed that rule, then we'd be a society of blind and toothless people. So we don't actually poke out people's eyes. We don't take out people's teeth. So by the time of the rabbis, in any case, so that's around the time of Jesus, we are no longer poking out eyes. We are interpreting the Bible to mean that you pay money to compensate for the lost eye. You figure out what the value of the eye was, and you pay money to compensate for the lost eye. That starts to sound like American law. Not only that, but they found another verse in the Bible that says you need to heal the person, so you have to pay his medical expenses. Now it's sounding more like American law. Then it said something about pain that you caused. You caused him pain, so you have to compensate him for his pain and suffering. Then, amazingly enough, they found another verse that said that basically they interpreted to mean, and if he's recovering and he can't work, you need to pay him for the lost wages he would have earned while he's recovering. So when I was studying this in law school, it looked a lot like I was in California, the California jury instructions, right? How you calculate damages for an injury. And by the way, one other category, if you did it on purpose, you have to pay a penalty, right? We would call these punitive damages, right? So basically, Jews had figured out about 2,000 years ago the elements of compensation for personal injuries. And that was the law. The Talmud then takes that's stated in the Mishnah in the year 200. The Talmud then argues for a while, what do you mean we pay money for the lost eye? Doesn't the Bible say an eye for an eye? Maybe it means literally poke out an eye. And for several pages in the Talmud, they argue why it can't possibly mean poke out somebody's eye. Right? If I was an Orthodox rabbi, I'd tell you that Moses understood it to mean paying money, but I'm not Orthodox. I'm a conservative rabbi, so I understand the historical context, and I will tell you probably Jewish law changed over the 1,000 years since Moses' time, and people said, you know what, that's pretty barbaric. We're not doing that anymore. We're paying money to compensate for the lost eye. So that's the importance of understanding interpretation in Jewish tradition. What allowed the rabbis to do this? So they found a verse in the Bible which says, go to the judges of your day. If you find a case that's too difficult for you to adjudicate, then you need to go to the judges of your day and follow what they tell you to do. So basically, that's the Marbury versus Madison of the Torah, right? They gave the power to the judiciary, in this case, the rabbis who are interpreting the Bible. Another example that doesn't necessarily relate to American law, but there's a verse in Deuteronomy that says if you have a stubborn and rebellious son, and he doesn't listen to his mother and his father, then the parents are supposed to take him to the elders of the city, and they're supposed to complain to the elders. Our son is stubborn and rebellious. He doesn't listen to what we say. He's a glutton and a drunkard. And then you're supposed to stone him to death. Needless to say, by the time of the rabbis, they weren't about to do that. If we did that, we wouldn't have any teenagers. So the rabbis couldn't get rid of the law on the books. It, after all, is the Word of God. So what they did was they did what any good lawyer would do. They interpreted the law out of existence, right? What does it mean to be a stubborn and rebellious child? And they said, well, you know, if he's, the age of majority in Judaism is 13. I know that sounds pretty young from American ears. Back then, if you were in an agrarian economy, I guess at 13 years old, you could be somewhat independent in any case, and people matured maybe faster, who knows. In any case, if he was 13 years old, well, first of all, the rabbi said, it says a stubborn or rebellious son, not daughter. So conveniently, they excluded half our population right away by saying girls don't apply, right? This only applies to boys. When they felt like it, and it said son or children, they included girls, but in this case, they were trying to narrow the scope of the law, so they said only applies to boys. Then they said, if he's 13 years old and he's not following what if you like, so then he's old enough to be on his own, kick him out of the house. And he's not your problem anymore. And then they said, and by the way, if he's too young, and this should be obvious, if he's like 5 years old and he's stubborn and rebellious, well, you're the parent, you're supposed to train him, teach him to be good. That's your job, right? So at some point, so when does a stubborn and rebellious child become one who's eligible for this punishment? They said 12 and a half years old. 12 and a half, if he hasn't learned from you yet, then he could be considered stubborn or rebellious. So you have a 6-month window where he might be subject to this penalty. And then they found all kinds of other ways to exclude any possibility of even any child in that window being subject to the penalty. One of them is that any capital case had to have 2 witnesses. Both witnesses had to see the entire culpable event happen from beginning to end so they could testify to all the necessary facts. They both had to warn the defendant, the potential defendant, what you're about to do is a crime. Yes, I understand. It is a capital offense. Yes, I understand. We will testify against you. Yes, and you will be put to death. Yes, I understand. Right? Obviously, that doesn't happen very often. In any case, they found ways to exclude it, and at the end of this long Talmudic argument, they said, we never had a case of a stubborn and rebellious child. Isn't that interesting? So that's how they dispense with that. Again, it's important to understand that in Jewish tradition, the power of the oral tradition and the rabbis to interpret the text. I guess I was going to talk a little bit about some issues that relate to American law. One of them deals with sort of medical issues. How much time do I have left here?
5 more minutes or so.
4 minutes. All right, so I
5
don't want to spend too much time on this. In the Q&A, if you're interested, we can talk about it more. One of the issues where we differ with Christianity is about when a human being is considered a human being. At what point a fetus becomes a human being. In Jewish law, it's extremely clear that it's not a full human being until it's actually born, till it's out of the mother's womb, or halfway out of the mother's womb, technically. But now that's not to say, in terms of abortion, which is where this usually comes up, that Jewish law permits abortion. It doesn't, but not because the fetus is considered human, but more because it's considered part of the woman's body. At least that's one way to understand it. So in Jewish law, though, I'm not permitted to cut off my own hand, even though it's my body. Why? Because we don't consider ourselves to be the owners of our body. We're lifetime tenants of our body. God's the owner, right? So just like a tenant of an apartment complex can't knock down walls, change things, whatever, without the owner's permission, we're not allowed to injure our body. And so we're not allowed to injure it unless there's a good reason. I can cut off my hand if it's gangrenous and I need to save my life. And that's the key difference here for abortions. For sure in Jewish law, if the woman's life is at all in danger, her life takes priority and you terminate the pregnancy. Then there's a sort of a gray area in Jewish law of what happens if it's not her life, but her health or even her emotional health. And there are some liberal interpretations in Jewish tradition that would allow for an abortion in those cases, so that, for instance, in a case of rape or incest, if it's going to cause emotional trauma to the woman to carry the child to term, then many authorities would say she's allowed to terminate the pregnancy, and other situations like that. So that's that area. And the other area, what I want to mention is, about evolution, whether we should have evolution taught in our biology books, and whether we should put a disclaimer in our biology books. Oh, by the way, there is this other theory called creationism. So my personal opinion as a rabbi is, I do not want a disclaimer in a biology textbook. Our schools are supposed to teach science. Science is biology, and that is evolution. I do believe that God created the universe, but that's my job to teach my congregants how I think that fits with science. I don't think that's the place of a teacher in the public schools to do, because whatever they're going to say, I'm sure I'm going to disagree with. So I'd rather that they just teach biology and evolution. That's what their job is, and I'll teach the religious aspects. That's my job.
Okay, so just keep in mind that we will have questions and answers, and when you're talking to Rabbi Steve Morgan, keep in mind that you're having to come up with or faced with both a rabbi and an attorney. So
I don't bite.
So anyway, and I also want to say that Rabbi Morgan is a member of the American Jewish Committee, as well as a past board member of the Jewish Federation of Greater Houston, Interfaith Ministries, and a senior rabbinic fellow of the Shalom Hartman Institute in Jerusalem, and a past president of the Houston Rabbinical Association. Our next speaker is our attorney, Murtaza Sirtawala. And Murtaza grew up in Houston. He lived and worked several years overseas. He attended as an undergraduate in the very cold, windy, and dark city of Chicago, where he got his law degree. Before that, he was at the University of Texas. He worked for Latham and Watkins. He has an interesting background because he has practiced not only in Houston but overseas. Now has started his own firm here, and is going to have the talk about Islam and the Muslim point of view of religion and law.
Thank you so much. Should I come to the?
Either way you want to do it.
Good afternoon. Sorry I was running late. To make it relevant, it was Friday afternoon prayer, so that's my excuse. Thank you for having me. Thank you for the introduction, Bob. So I wanted to just... okay, sorry, I'm just going to wait. We have a Simpsons clip about Sharia from the TV show The Simpsons, so she's just getting that ready. So.
Oh.
And we can do it at the end. Yeah, we can do it at the end. Sorry about that.
Murtaza is, I want to fill in a little bit here. Practices in the area of corporate and business organizations, commercial transactions, trust and estates, international and cross-border. I'm not too sure what exactly cross-border is, but maybe you can enlighten us on that area. Business litigation, immigration, real estate. So, and is happy to see that at least Texas won one game against Oklahoma this year.
Sorry about that technical. And I can get started. So the first, it was interesting to come up with a title, in fact, of the presentation. I came up with at the end, Sharia in the context of modern transactions, and I'll just develop a little bit. The rabbi did an amazing job just explaining Jewish law and sort of bringing it to the context of America today and the deep issues. So I appreciate you opening this talk. So the first thing that I wanted to talk about, just give a little bit more on my background. As Bob was mentioning, I grew up here. I'm a Texan, native from New Jersey, and second-generation American. I grew up here in Houston. I went in law school. I studied Islamic law and theory with Professor Robert Bianchi. He's a pretty well-known legal and sociological professor, and it was the first time that Islamic law had been taught at my law school, University of Chicago. And it was also my first formal exposure to Sharia other than just growing up Muslim. After I graduated, I worked at Latham & Watkins, first in Washington, D.C., doing commercial transactions of all sorts and M&A transactions. When Latham & Watkins in 2008 decided to open up offices in the Middle East, they opened up 3 offices, one in Dubai, one in Abu Dhabi in the United Arab Emirates, and the third office in Doha in Qatar. This was sort of the peak of foreign investment, right, I want to say 2 months before the global financial crisis hit, so before Lehman went down. That's when we set up there. There had been numerous American firms already set up in Dubai. There had also been British law firms there. And the British connection is important because United Arab Emirates was formerly a British protectorate for about 100 years. It was under the protection for foreign policy from UK. So the experience there was pretty amazing. I mean, and I'll get into more detail on why being an American lawyer overseas is such a good experience. If anyone's thinking about, revitalizing their career or wants it in another location, you should think about practicing overseas. And I'll explain some benefits in a second. While I was in Dubai, I was lucky enough, because Dubai is sort of an international hub, and part of that is because of Emirates Airlines. I don't know if anyone has ever flown. So the government of Dubai said, how can we catch up? We're now out of oil. They ran out of oil in the late 80s. With a very small amount of oil left. What can we do? So they said, well, naturally, everyone is flying through when they're flying over our part of the world when they're trying to get to Asia or they're trying to, even to Europe. So they really put a lot of money into the airport. That also led to really developing their port. So Houston is a port city, but Dubai is Houston on crack in terms of being very international, very port. And you have transactions going across. You'll see in the center of the town the traditional dhows, the traditional boats shipping goods to Somalia or to Iran. You'll have the large, so anyway, the experience was great in getting international exposure. I was lucky enough on working on transactions throughout the Gulf Cooperation Council. So I'll refer to the Gulf Cooperation Council a lot in my presentation. So the initials are GCC. It's 6 countries, all surrounding basically the Persian Gulf. They are culturally Arabic. Their background was Arabic and sort of the heartland of Islam in one sense. It was sort of where Islam started out from. But they're very different the way that the 6 are. Saudi is part of them. Saudi Arabia is one of the 6 countries. And UAE is one of the other countries there. Bahrain, Qatar, Kuwait, Oman. Right now, if you've been reading the news, there's a huge controversy going on. Qatar, which is a very small state next to Saudi Arabia, is in a foreign policy dispute with the GCC. So there's talk of the GCC going away, which, having practiced in the Middle East, is like today saying, not the United States, but saying the Confederacy, the original Confederation of the United States is going away. It's a pretty big deal if the GCC goes away. And it'll be interesting to see what happens in law and politics if the GCC actually goes away. In addition, while I worked in Dubai, we represented the government of Dubai during the global financial crisis. So when the stock markets were falling because Dubai announced they might not be able to meet their debt obligations, we were there on the ground. Interestingly enough, they had a bankruptcy law which applied on its face to the government of Dubai if there was a bankruptcy that happened. But the government said, we don't want this law to apply. It's too creditor friendly. So our office helped write the new law, which then applied specifically to the government if it filed for bankruptcy. It's called Law Number 57 of 2009. As an American lawyer, what we did was we took the US bankruptcy code, and there are some nice things from the UK bankruptcy law, put it together, and then the Dubai law is basically not completely, but a controlled replace of wherever it says US, it says UAE. And that's the law. And the reason for that was that international investors knew the US law and were comfortable with the bankruptcy law and were willing to allow the country to change its law completely after a bankruptcy situation is about to arise. In addition, while working in Dubai on complex transactions, you'll see that most transactions actually are not governed by the local law of the countries in the Middle East or the Muslim world. They tend to follow UK law. So if you have international parties, where you have one international party and one local party, they'll tend to pick UK law, which sort of abrogates the right of Islamic law in any case. followed by, if you don't agree on UK law, it's New York law, then local law, and then French law, interestingly enough. After the experience in Dubai, I moved to Clifford Chance in Riyadh, and that was so while Dubai was very international, very global, Saudi is a little bit different, at least, and especially in the years that I was there, 2010 to 2013. Very domestic, very inward focused. And I guess that's the best way to describe the difference between UAE and Saudi Arabia. They were not affected by the global financial crisis at all. Only thing that affected them was when oil prices hit $47 a barrel, there was big concern there. But when it came back up to 100, they were fine again. They were actually worried more about the Arab Spring, which was happening during the time. So the Arab Spring was 2010, 2013. You can even say it's ongoing now in places like Syria and Yemen, where the population was just sort of, in each of the countries where it happened, was fed up with the ruling class that was there and wanted a new world. The Arab Spring led to, interestingly enough, in places like Tunisia and Egypt, which were known to be very secular countries in the 20th century, very secular. You had the initial group of politicians who came about were Islamists, right? And we'll talk about what Islamist means later on in the presentation. In Egypt, that Islamist revolution had a counter-revolution, and we went back to what's originally there, the military ruling the country. But anyway, the bottom line was a fascinating time to be overseas. The issues that you would see on the news here was actually happening in front of, in our backyard while I worked there. Some of the general, excuse me one second. Go for it. I'm gonna go back. So general observations about lawyering overseas. This is it's slide number 5. At a simple way, you get to go overseas and explore new cultures and new legal systems. And I think one of the great things I love about law is that you're always learning something new every day. The experience overseas brought back valuable contacts, hands-on experience. So the way that we were taught law in the 18th century in America through apprenticeships, you just sort of hands-on, you learn. You get to do that when you go overseas. And insight on how to better advise on U.S. law. So Bob mentioned, what does cross-border law mean? So a Texas lawyer can advise on Texas law with pretty much confidence, right? A Saudi lawyer or a UAE lawyer can advise on Saudi law. What a cross-border lawyer is supposed to do is explain how those two laws interact, and are there any conflicts or contradictions with one another. So an example, it's quite common, you've probably seen all contracts, there's a provision which says that each party represents and warrants that they will comply with the applicable law and regulations, or they'll comply with local laws and regulations. You probably have seen them in probably 99, if not 100% of the contracts you deal with. Well, as an American, you actually can't agree to complying with Saudi law or UAE law. Why? Number one, those countries in very tight ways, a little bit loosened now, but they have a boycott of Israel, right? So when you agree to comply with Saudi law, you're agreeing to comply with the boycott of Israel, right? And the Saudi boycott says that you cannot do business with Israel, you cannot do business with a party that does business in Israel, and you cannot do business with anyone that has any Israeli elements. That's the strict interpretation. That's loosened a lot in the last 5 years, that's changed. Well, as an American, there's actually a law called the Anti Boycott Law, which says that if you boycott Israel, you are committing a violation of US law, you're subject to potential penalties from the Treasury Department, and you cannot take a tax deduction on that contract. Until we got there, not to say that I was some genius in figuring it out, we would have all of our clients who are agreeing to do something illegal under U.S. law. So that's really where a cross-border lawyer comes in and says, look, you can't do that. So the workaround was scratch it out, right? If you're negotiating on behalf of the U.S. party and say we can't do it, and say, look, we're going to comply with law. Obviously, we're going to comply with law, but we're not going to agree to it contractually. The second thing is you can put carve-outs out that says to the extent you don't comply with, you don't have to breach American law, you'll do it. Then they'll ask you why, and you say, well, it's because of the Israeli boycott, and then you get levels of smirking or smiling or whatever. But everyone agrees with why you can't agree to that language. The additional point is when you go overseas, there are a lot of lawyers that I met who used to just have practices advising expats. So you'd have U.S. immigration lawyers sitting in places where people were immigrating. US family lawyers, they did actually quite well. UK family lawyers did quite well in Dubai because you had so many UK expats and they were getting divorced, they needed a lawyer. So if you ever do think about going overseas, this is another thing you can think about. Finally, when I came back to America in 2013 and set up my own practice, I definitely had a newfound appreciation for how great our country was. Just seeing how things worked and didn't work overseas. When you come back, you get that joy in your face. And most importantly, as a lawyer, I saw how special our Constitution is and how rule of law is. And that's, no matter what, the Constitution is always there. And it's something you will appreciate when you leave it and you don't have it and you come back and you're like, wow, I can get my rights addressed by any court. And from there. So anyway, that's just basically it. Another thing that was interesting, I had different titles while I was working overseas as a lawyer. And it's interesting because I think it shows our value in the systems that we go to. Here we get JDs, Juris Doctors. Doctor is Latin for teacher or instructor. The Supreme Court of Texas licenses as attorneys and counselors at law. It's on all of our licenses on our walls. What does that mean? Attorney is, from French, for persons acting for another, and counselor trained to give guidance. In the Muslim world, there are different titles depending on whether you're in the Arab world or you're in the Persian and Turkish world. So we would quite commonly be called muhami in the Arab world, or muhamiyin, which is the plural of it. What does that mean? The root word, it comes from himayat, which means that person who provides guidance and protection to another. Which, if you think about it, that's pretty amazing. That's what we call. And I was just visiting right now overseas over Thanksgiving break, and people would ask, what do you do? And I say, Ana Muhammad, I'm a lawyer. And they would always, perk up because it's a title of respect. In the South Asia, Persia, Turkey, those parts of the world, lawyer is called a wakil, which means an agent, and it means an agent with fiduciary type duties. I was also called a mushtatar kanuni, legal advisor. The other three are sort of old references from the Quran and from medieval times. Khatib, which means a scribe, right? You'll see that in the Old Testament, there's a scribe to write down contracts. It comes in the context of Islamic law because when you have a contract of debt, you have to have a writing by a khatib, by a scribe, because if you're not literate, you need a scribe to write it down for you, and you need 2 witnesses, and the subject matter has to be lawful. So that's why a lawyer is important there. A qadi, that's a judge. The equivalent would be a trial court judge here. It's the person who does the qaziyah, which is a root, which means the dispute between people. And the last one is faqih, which is a bit unique. It means a jurist. The closest analogy would be an appellate court, a Supreme Court, justice, or a law professor. So it's somebody who doesn't get in the weeds, doesn't have to deal with the record and the evidence and all of that, but just gives proclamations on what the law is. There's a saying that Muslim lawyers have, everyone wants to be the faqih, nobody wants to be the qadi, which means everyone wants to just give pronunciations on what the law is, but no one actually wants to get into the details about facts and guilt and so forth. Okay, so that's a little bit background on working overseas in the Muslim world as a lawyer. Going forward on what is Sharia law. We'll go to slide 8. So Sharia law, I was at a conference recently, the National Association of Muslim Lawyers had a conference in Dallas. And there was a whole conversation on what is Sharia law. And the first 20 minutes was spent on Sharia law is actually a misnomer. You hear it quite often, in the news, wherever, we're worried about Sharia law or Sharia law is coming or Sharia laws exist. It actually doesn't really exist in that sense. It's a bit redundant. Sharia means law in its basic sense. So you're saying law, right? So it's a bit stupid to say it, but and not again, like I said, not necessarily accurate for what the media refers to as Sharia. The classical definition, and probably the one that's most widely accepted by Muslims, is it refers to the entire body of divinely ordained law from Allah, from God, revealed to His messenger Muhammad, peace be upon him, that encompasses the right path for every aspect of life and death. Okay, so let me break that down. Entirely body of divine ordained law. So Muslims, Islam, the definition of Islam, one translation is surrendering to the will of God. You probably heard of submission to the will of God. What that means is that God revealed a path, and it revealed it to certain prophets, right? and that you follow the path that's revealed to that. And if you do that, you have a pretty good chance of getting to heaven, right? In the end. Or if you don't, unless you, and then the other thing is God is merciful, so hopefully you don't end up the opposite place, which is hell. But that's different. So, and by every aspect, I honestly mean every aspect. There's literally no aspect for practicing Muslim where Sharia does not come into play, okay? So I listed here the way you wake up, eat, walk, pray, practice, deal with others. Criminal law, family law, business transactions, everything comes back to Sharia. And what that means, I'll get to that in a bit. So for example, this ring that I'm wearing on my finger, right? Okay, so for example, this ring, it's a silver ring on my pinky finger, ruby, okay? So the pinky finger is the preferred place that the Prophet Muhammad used to wear. On the right hand is where the Prophet Muhammad used to wear his ring. Okay, so that's number one. Ruby is seen as the best stone for men to wear, so that's why there's a ruby there. It's meant to be as least ornate as possible, so you're not showing off. That's why it's a simple ring that goes there. If you wear the ruby ring in prayers, it's one prayer counts as 19 prayers. You get the benefit of 19 prayers, right? So you wouldn't, if you see anyone in a casual observance, you wouldn't, why am I wearing a pinky finger, right? But that's a ring on my pinky finger. That's the reason why. Going further, Muslims believe that this divinely ordained law has been present in every age. So Sharia today is what we believe was revealed to Muhammad, who was, as everyone knows, prophet in Arabia in the 6th century or 7th century, and is interpreted by qualified persons. So the qualified persons will keep you fighting for, this is the year 1440 in the Muslim calendar. You'll be fighting for 1440 and probably until the end of time on who is a qualified person, okay? And I'll get to why the reasons for that is. In previous ages, Muslims will believe that Sharia, or the law that God wanted, was revealed to earlier prophets. So there's a Sharia that Noah brought, that Abraham brought, Moses brought, and Jesus brought. So a Muslim would say those people were also Muslims. So that itself is a controversial statement I can understand for other religions, but that's the Muslim view on that. Okay, going further. So breaking down Sharia, okay, what it means. So first thing is the revelation, including scripture. Scripture being the holy book Quran, which is Muslims believe from Allah to Muhammad. That's the first part of Sharia. Then there are principles called usul, which means a theology. I believe in God. I believe that Prophet Muhammad is his messenger. That's the theology and creed right there. Religious practice and ritual, worship. So that's called, the word is fiqh, so it's pronounced, spelled F-I-Q-H, fiqh of ibadat. Ibadat means worship. The best way of putting this is the pillars of Islam. So if you ever hear the pillars of Islam, they're referring to religious practice and ritual. I actually have a book called The Pillars of Islam, which I'll describe in the next slide over what this Pillars of Islam book means. And then the next one is the laws of human intercourse, which is also fiqh, F-I-Q-H, which means law, of muamalat, which is human intercourse. Okay? This is actually volume 2 of the fiqh book that one community uses in Islam. And so this book has sections, they're all called books. There's a book on divorce law, book on family law, book on inheritance, wills and trusts, guardianship, law of torts, business law. So this book also includes how a sale should be conducted, how a lease should happen, how contracts, debts, etc. Law of day-to-day life, so that means how do you slaughter an animal for eating. Laws of foods and drinks, laws of hunting, laws of everything, and that's all in here. Laws of the state, so when you have a Muslim state, what laws does the state have to abide by? So that means criminal law. Criminal law is interesting. In Sharia, there are two components to criminal law. There's a private aspect and there's a state aspect. So if you murder someone, the family of the deceased or the murdered victim is entitled to take a certain punishment on the murderer. And that can be death, it can be a money payment, or it can be complete forgiveness. The state aspect is, so let's say the family says, look, we just want this amount of money for the deceased, we're fine otherwise, or we'll forgive him. The state says, well, you caused a murder, you caused harm in society, we're now going to punish you in addition to that. So almost like double jeopardy. It's slightly different than torts law. There is a law on like values, as a rabbi was explaining. There's a book on how do you interpret the value of like a lost finger and a lost, we have that, it's actually here as well. what else? This laws of the state also includes laws on military and courts. And then finally, laws of treaties and agreements with non-Muslims. So laws of treaty means if there's a Muslim state enters into a treaty, what does that mean? It also implies the laws of people who come from overseas to Muslim countries and vice versa, right? So the next slide. I know this is a lot of information, so I'm trying to be quick about it. Sources of Sharia. So where is the Sharia derived from? Number one, Quran, which I talked about. That's the holy scripture revealed by Allah to Muhammad. And then the next is Hadith and Sunnah. What that means is it's the life and quotes of Prophet Muhammad during his lifetime. And they were collected, and there are scholars who basically spend their whole career on one statement that the Prophet Muhammad made. He said it to so-and-so person, who said it to so-and-so person, who said it to so-and-so person, and they were all codified into a book about 150 to 200 years after the Prophet Muhammad passed away. So you have to trace who said it to this, to this, to this, to this. And their scholars will say, well, they'll study the line of that transmission of that quote. They'll go to the background of the person. They'll do sort of like a TLO search on the person in the middle, whether he was an honest person or a liar. It's a very political exercise, as you can imagine, right? Because, and again, it's frankly similar to the game of telephone that you play as kids, right? You start from one thing, go from the other to the other. But that's a controversial subject, so I'll let that be. But as a lawyer, I can see where this leads to. But there are certain things that he said to many people in public that are pretty much universally accepted, right? It's not every single statement is like controversial. There's some there are, but probably 80 to 90% are not controversial. The next four sources are qiyas, that's analogy. So these four, the first two are pretty much universal, right? 99.99% of people will agree that the first two are valid sources, don't need to be questioned. You got to question maybe who the source is on the second one, but they're accepted. So that's Quran and Hadith. For the other four, very controversial in some sense. Qiyas is analogy. What that means is that if there's a principle set now, can you compare it to something that's happening today? Sunnis accepted some schools of thought in Sunnis, but not all. Shias don't. And again, Sunni Shias are people familiar with Sunnis and Shias are? The two major schools, or divisions in Islam are Shias and Sunni. Ijma is consensus of the community. For Sunnis, they say that consensus of the community, once the community reaches a consensus, that is a holy decision. And the community as itself cannot be fallible. That's in the classical Sunni thought, that the community can't be wrong when they're acting in community. Sort of like Congress can do no wrong, right? Or Parliament can do no wrong. Ijtihad, that is reasoning by a very learned person. And by very learned, it's very learned, right? Like all the years and all the books and the right people like you and you get elevated, to the position. Shia thought accepts the concept of ijtihad for very limited people. So I'm talking 1 to 4 people in the world have this authority. The ayatollahs. So if you hear ayatollahs, that's usually the people who have this right, but not all of them. Some of them just take on the title and they're super ayatollahs who do have the right. And then this final one, interpretation of the Imams of each generation. This is limited to Ismailis. So in Shia, there are a lot of sects. In the Shias, there are two major sects. Ismailis are the smaller one. They say that God has put a representative on earth forevermore. And that person is either known or not known, depending on which community you fall into. But that person, when they make a ruling on Sharia, they are speaking authoritatively. Whatever they say, it goes, right? And they're infallible, so they can never make a mistake. That's part of the beliefs. So that goes. Okay. So schools of thought. The next one. Islam is split into several denominations. There's a saying of Prophet Muhammad where he said there will be 72 sects in Islam, but only one will truly be on the right path. So you can imagine, there are a lot of, I think the 72 sects all claim that they're the one. But funny enough, this subject, on this topic, there's another alternative saying which says that he actually said 73 sects. So there's on the statement. There's some disagreement.
I need to.
Yeah, sorry. I'll go quickly. So anyway, there are schools of thought, 4 in Sunnis. All the names refer to the founders. In Shias, there are 2 schools of thought. Jafri and Zaidi. Zaidi are in the news because of Yemen. The Houthi rebels fall from that. Jafri covers Iran, Iraq, Bahrain, and other parts of the world. There are other groups who are smaller, but they're considered within the framework. So this map, I'll go to slide 13. Just bring it to the modern world. So what is Islamic law? So I'm going to stop referring it to as a Sharia law because it refers to too much. Islamic law is a better way of referring to it, I think. In the modern world, this is a map of all the countries which are part of the Organization of Islamic Countries, and plus a few more. But basically it says, so if they're purple in the middle, most of them are members of the GCC and fully apply Islamic law. Yellow is the countries that only apply it in their personal law, so family law, divorce law, and inheritance. Those tend to be former British colonies. So the British, when they colonized the world, they were pretty good about accepting the local laws of the region, but then putting in other laws for other things. So India is one of them, but all of these are former British colonies. Orange is the country itself is not 100% Islamic. Nigeria, for example, north part of it is very Islamic, the rest of it isn't. And green are countries that have purposely not incorporated Islamic law. One example that stands out is Turkey. It's officially secular, though 99% of the people are Muslims there. Anyway, the point of that slide was to show Islamic law, Islam is not a monolith. It's very different from places, you go place to place. Some countries have full incorporation into their law, Saudi Arabia. But Saudi Arabia has one very important exception. Interest, so the paying of interest is haram, it's not allowed under Islam. But Saudi Arabia, though it says our law is based on the Quran and Islamic law, does allow interest to be paid on international banking transactions. So if you make a loan with Deutsche Bank or one of the big British banks, the debtor might be required to pay interest. The way they got around it is the courts are generally Sharia courts, so they're law courts which have the qadis who are Islamically trained. And these judges said, no way over my dead body we will allow interest to be paid for a banking transaction. This is against everything we believe in. So what the king did at the time was he set up committees, which are basically administrative bodies, administrative tribunals, which will then allow interest to be paid. So he stepped around it by saying, okay, well, that's fine. We'll just go to another committee to do this. Anyway, and we talked about the Turkish approach and the British rule and how it influenced in segregating issues. Islamic law in America, I'll go to the Islamic law.
I'm going to have to cut you
go
off.
ahead. Okay,
I'm sorry.
That's
We'll
fine.
hold that for the question and answer. Okay,
course.
we're talking about Islamic law in the United
That's
States.
fine.
And I need to move on to Hiram Sasser. Mr. Sasser is the General Counsel for the First Liberty Institute, where he oversees First Liberty's litigation and media efforts. His practice focuses mainly on First Amendment and other constitutional civil rights issues. He's now working on a brief case just been cited. It will be presented to the United States Supreme Court on the issue of the Establishment Clause. Some of his clients include the American Legion, the Fraternal Order of Eagles, Native American Sweat Lodge, I'd be curious about that one, Jewish Educational Center. Before joining Liberty, Mr. Sasser graduated summa cum laude from the Oklahoma State University School of Law, where he received recognition as the outstanding graduate. He earned his bachelor's degree from Oklahoma State University, and in 2016 he took a leave of absence to serve as temporary assignment as the Chief of Staff for the Attorney General of Texas, which I'm sure was interesting. So, Hiram, the floor is yours.
Thanks for having me. The first case I ever had in Houston, by the way, was representing the Falun Gong. I don't know if you've ever heard of the Falun Gong. It's an Asian religious group of people, and they were staying in a hotel here. I forget which it was, a Homewood Suites, or gosh, this was probably 14, 15 years ago. It was near the Intercontinental Hotel here in Houston, and the Premier of China was visiting, and they wanted to be able to be in close proximity to protest the Premier of China, because in China they're harassing and discriminating against the Falun Gong, and so the Chinese government got wind of that, and so they bought out all the rooms from the hotel. And so we we had a client, the Falun Gong, and they wanted to know, well, what could they do about it? And I said, well, we could sue them for discrimination in a place of public accommodation, but the Falun Gong don't believe in confrontation, so they don't believe in suing anybody. So, like, well, how are we supposed to do all this, right? So we got the Department of Justice to look into the hotel chain, and so the Department of Justice got to be the bad guys for us, and we were able to get a nice solution worked out that everybody was happy with. I don't know if I'm allowed to travel to China anymore after doing that, but anyway, so that was kind of a fun little matter. Another one we just recently won at the Ninth Circuit was on behalf of Orthodox Jewish Synagogue. The animal rights activists have been all over the country suing the Orthodox Jewish synagogues for killing chickens for a ritual called Kaporos, right? And what they do is, they take a chicken. There's a waving over the head of someone to transfer the sin from the person to the chicken, and then they kill the chicken. If you need more details, there's lots of animal sacrifice in the book in the book of Deuteronomy. There's animal sacrifice is pretty central to most ancient religions. Well, the animal rights activists are very upset about this, although I don't know that they get anywhere close to killing as many chickens as Chick-fil-A does, but for whatever reason, they come after the synagogues. And what they do is they typically will try to pick sort of the poorest or sort of like the slowest moving synagogue. In other words, one that has a smaller congregation, so they won't have the resources to go fight, so hopefully they can get a precedent established. This happened in Irvine, California, the Chabad of Irvine. The animal rights activists were able to get a TRO to prohibit them from killing any chickens. And so we had to come in and get the TRO dissolved. And so it was sort of cool to represent a practice that's at least historically derivative of other practices that had survived, the test of time, whether it was the Babylonians or the Persians or the Romans or the Greeks. But for whatever reason, there was it met its match in federal court in California. But we were able to get that reversed and then ultimately prevail at the Ninth Circuit just a few weeks ago, which is, I think, pretty cool. Another case we just launched is in Airmont, New York. The town, and you can look on their Wikipedia page, but they were founded for the purpose of excluding the Orthodox Jewish community, and they didn't want the Orthodox Jewish community sort of infesting their town, and so that's how they talk there. It's sort of every 10 years or so, the Department of Justice has to sue Airmont for its discriminatory practices towards the Orthodox Jewish community and driving their synagogues underground. Because the Orthodox, they walk to their services, and if you imagine a suburban area that's sort of where lots are rather large, like 35,000, 45,000 square feet lots. You can see where, and especially during harsh winters, you could see where synagogues have to be small and meet in people's homes. You're not going to be able to have it's different. Like in a city, for example, it's easier to have larger congregations, but you're going to have small home-based congregations for the Orthodox Jewish community in a suburban setting like that. And so they've just been harassing the Orthodox Jewish community for decades. So the Bush administration, George Herbert Walker Bush administration, had to sue them to get an order. The Second Circuit basically outlined the history of why they're discriminating against the Orthodox Jewish community. And then the George W. Bush administration also had to sue them and get a TRO. And the Obama administration continued on the tradition of suing the city of Airmont. So we're continuing the tradition as well of suing Airmont on behalf of the Orthodox Jewish community. The most recent tactic was to say that you can only use a certain percentage of your own home for religious purposes, and some of those religious purposes include how much square footage of your home is taken up by the library of books that the rabbi has. So your storage closet of books is also part of the religious use, and limits how much of the percentage of your property or your house that you can use for religious purposes. We have rabbis who had people coming over for prayer meetings in their garage, where you can't meet in your garage. You can have a Super Bowl party. You can have your Baptist Bible study meeting, but you can't have your Jewish meeting. We're getting after those guys on that, and that's a lot of fun, suing those guys. Another interesting case that we had was the Islamic Association of Collin County up in, just north of Dallas County. We have another case, like I just described with Airmont, going against the city of Dallas right now. And so they called the rabbi there to find out who they were using, who were they using as counsel to sue the city of Dallas for prohibiting a home-based synagogue. And they said it was us at First Liberty. And so on the recommendation of the Orthodox rabbi, the Islamic Association of Collin County called us to represent them, and we did on this cemetery issue. They wanted to build a cemetery in a more rural part of Collin County, and the local government there did not want them to be able to build a cemetery. And we thought, well, that's pretty outrageous. It's just a cemetery. And at first they were concerned about the decomposing bodies contaminating Lake Lavon, as if no possum had ever died on the shores of Lake Lavon. And so we ended up representing the Islamic Association of Collin County, got after Farmersville, and were able to prevail, and now they'll, at least the folks there will not have to suffer the indignity of not having a place to bury their loved ones when they pass away. And they won't have to drive, a great distance to another Islamic cemetery to be able to do that. And from what I understand from our clients, I mean, people visit the cemeteries. It's not infrequent. And there's a lot of visitation, so it's going to be good for them to be able to have their cemetery. So we do religious liberty at First Liberty Institute for people of all faiths. They talked about the Native American Sweat Lodge. I won't get into that story, other than during our press conference, we were threatened with arrest for being on government property without authorization. And we said, well, sure, as long as the cameras are rolling, feel free to arrest us. And so they didn't do that. But anyway, that all worked out. I have a brief moment here. I'll just tell you about the Bladensburg Veterans Memorial case. The American Legion and the mothers of their sons who had died in World War I, mostly in one of the last battles of World War I in October of 1918. There were 49 of them from Prince George's County, Maryland, who died there. And the moms of all of them and the American Legion got together and thought there should be a memorial to them. Most of them were buried overseas. And so they chose the monument architecture of the day, which was a large freestanding cross. If you go to England or Canada or New Zealand, their World War I memorials are predominantly large freestanding crosses. It was just the memorial of the day. And so they chose a large freestanding cross, and they put it on American Legion-owned land in Bladensburg, Maryland. Well, over time, the highway expansion there led to the government having to seize the land and basically run a highway on-ramp loop around it. So the only thing the government did was, when they seized the land, they did not tear down the memorial, to these 49 men who was chosen by their moms. And that's basically it. Well, it stood there for about 93 years until the American Humanist Association, actual grown adults, drove by on the highway and looked at it and said, I'm so offended that I can't handle seeing this as I drive by, and therefore I have to sue in order to have it torn down. So they sued the Maryland Commission that handles the parks and everything there. And we represented the American Legion, since our client's the one who put it up, and we intervened in the case. And the American Legion's a little over 2 million veterans from a wide variety of backgrounds. And it's certainly not a religious organization. It's just a veteran service organization to go defend the memorial and defend the memory of these 49 soldiers and Marines who died in World War I from that county, whose mothers had picked the grave. And as one mother described in a newspaper account when they put it up, that she can't visit her son's tombstone, which by the way is a cross, but this is his tombstone that I can go visit. We were in front of a judge in Maryland, federal judge in Maryland, a Clinton-appointed judge, and she ruled in our favor, and we preserved the memorial. We go to the Fourth Circuit. Our panel was a Clinton-appointed judge and 2 Obama-appointed judges. We lost 2-1. The 2 Obama-appointed judges outvoted the Clinton judge. And we lost 2-1 at the panel stage, saying that the memorial had to come down. Oral argument was on Pearl Harbor Remembrance Day, and Judge Thacker thought it was appropriate to say, well, why don't we just cut the arms off of this thing in order to solve the constitutional problem? And of course, our response was deface a Veterans Memorial. I mean, sort of an interesting suggestion on Pearl Harbor Remembrance Day. The Washington Post ran an editorial to save the cross. A lot of different groups from different religious backgrounds have been filing to save this Veterans Memorial. We go to en banc. We lost 8-6. And so then we filed cert at the Supreme Court. Supreme Court granted review about, 2 months ago now. Our brief is due December 18th, and we're fighting to save this now 95-year-old Veterans Memorial from being torn down because a grown adult drives by and says that they're somehow offended in the 0.3 seconds they might see it out of their peripheral vision as they drive by on the highway. So we'll see what happens with that. But if you were to go to any European country and you go see their World War I memorials, they're all large freestanding crosses. By the way, there's 2 other World War I memorials in close proximity to this one that are large freestanding crosses too. They're both in Arlington National Cemetery. One of them is about 8 feet tall, and it's the Argonne Cross. And the other one is almost 30 feet tall. It's 29 feet tall, donated by that radical religious organization known as the Canadian government, and accepted by Calvin Coolidge to honor the Americans who joined the Canadian Armed Forces prior to America's entry into World War I. And why is it a large freestanding cross? Because it's the design of the memorial of the day. By the way, we had competing experts in the case. You'll find this quite fascinating as a lawyer. You always want to find an expert. We went out and found the world's leading expert on World War I memorial architecture. There's one, and we found him, teaching at Yale and Oxford, so that was kind of cool. And the other side had an expert as well. And you'll notice if you ever see our briefing on this from below, we cite to him heavily because he sort of became our expert, especially when he said there were no people buried under temporary crosses in World War I. And then we showed him a picture of the cover of one of his books he'd written several years ago, which had rows of crosses. So anyway, so it's been an exciting time in litigating this case, and now we'll see what the Supreme Court has to say.
Validation code 346615. 346615.
And we'll pick up with the questions and talk about with the Chief Justice of the Supreme Court saying there are no real political judges, they're just judges, right? Okay, let's move on, David. I'm not going to do the introduction. I want you to start. We're going to run past 2:30. It's going to be the way it is. And so just stay a little bit longer make sure we get all questions asked. So David, it's all yours. Sure.
Good afternoon. My name is David Furlow. I am not appearing here officially on behalf of the Texas Supreme Court Historical Society, but I've served for 8 years as the executive editor of the Texas Supreme Court Historical Society Journal, and I've served as a trustee. So one of the things I do is I tell stories of Texas history and legal history, and a good part of that is religion and its different influences on Texas history. I also, as Bob mentioned, I'm about to join the board of Pilgrim Hall, America's oldest museum, in Plymouth, Massachusetts. And there my connection is that I'm a descendant of the Reverend John Lothrop, who was a dissenting Puritan separatist leader of a congregation in London who ran afoul of the Episcopal bishop and Archbishop of Canterbury by the name of Archbishop Laud. And as a result of that was, on the basis of his preaching, tried in the Court of Star Chamber under Charles I, sent to the Clink. If you've ever heard the phrase the Clink, it refers to a prison in existence in London. And while there, his wife died and his children were reduced to begging for bread on the streets of London. So deciding that England under Charles I was not the most friendly venue, moved to Plymouth and organized a separatist church. His bishop's Bible is the oldest Bible on display in America's oldest library, the Sturgis Library in Barnstable, where he had his congregation. So what that means is, in my blood, I'm a believer in separation of church and state, because one of my ancestors suffered when church and state were united under Archbishop Laud, and before the time that separation of church and state became an important part of American history. Issues arise from separation of church and state, and so I find this area of law and history ultimately fascinating. Before I do that, I'll just talk about two of the presentations here that have just occurred. With respect to Murtaza, he was telling you that the Islamic judge is known as the Qadi. Well, there's a connection here with Texas, because that concept of the Qadi became the local magistrate judge and mayor as a term in Andalusia, that is that part of Spain that had once been part of Granada and then became part of Spain under the Catholic Kings Ferdinand and Isabella. And so the Qadi became the Spanish alcalde, or mayor with judicial powers. And that concept of the mayor with judicial powers came over to Texas, where our most famous alcalde was named Stephen F. Austin. In an article that Dallas Court of Appeals Justice Jason Boatwright published in our journal, tracing that back, and then he made a presentation for the Texas State Historical Association. So the Qadi becomes the alcalde, becomes the founder of Texas. There are connections everywhere. And then here, with respect to these stories of this, horrible town in New York, I'll take you back to 1655, when Pegleg Piet Stuyvesant was the Director General of New Nederland, or New Netherland, and a group of Jewish refugees of Sephardic background who had, when Brazil was conquered by the Netherlands, in the 1640s, the Netherlands and the Prince Maurice conquered Brazil. And then the Portuguese came back. And when they came back with the Inquisition. And so those Jews who had found freedom to worship and create their own, organize their own synagogues in their home in Brazil, suddenly were facing the Inquisition, and they made the decision that it was time to leave. They went to Curacao, which has the oldest official synagogue in the Western Hemisphere, and a group of them left on a ship called the Pereboom, or the Pear Tree, and were attacked by pirates and took their ransacked boat to the capital of New Nederland, New Amsterdam, which we know as New York City, and landed there, some 20 of them. And that's when Peter Stuyvesant said, and using the same words as this little jurisdiction in New York, we will not allow New Netherland to be infested with these Jews, and move to expel them. When, as it happened, Moses Abraham, who was an Amsterdam merchant, originally born in the Pale of Poland, but had made a small fortune as a businessman merchant in Amsterdam, happened to be trading there at the time in New Nederland, and he filed a remonstrance, essentially a mandamus petition, with the States General of the Netherlands and with the High 19, the directors of the board of the West India Company, or the West India Company, and complained about what Peter Stuyvesant was doing, and particularly appealed to those members of the High 19's board of directors who happened to be Jewish and happened to be very sympathetic to the Jewish refugees of Brazil. And they sent an order to Peter Stuyvesant saying, you have a choice. You can either accord these refugee Jews who lost all in our former colony in Brazil, and you can treat them the same way they would be treated with toleration and respect in Old Amsterdam and do that in New Amsterdam, or you can leave your jurisdiction behind and come to the West-Indische Huis in Amsterdam and explain your policies. Peter Stuyvesant decided that toleration was a better policy than exclusion, remained in New Nederland, in New Amsterdam, and it was there until he surrendered it to the Duke of York, transforming it into New York City, New York. So these same principles that apply now demonstrate that, little towns and little jurisdictions in New York or elsewhere may decide to take anti-Semitic policies, but in the long run, those jurisdictions suffer from mandamus relief and the benefits of a more tolerant view of litigation. Connections abound. Here, let's talk about some of the most interesting litigation going on. And there are people who say that there's a war on Christmas, over Christmas trees and public display of Christmas trees and things like that. And then there's some controversy with issues on both sides, like this Bladensburg case. These cases are actually decided more under an intense analysis that was used, for example, by a conservative Republican Judge Sim Lake in deciding the Bible monument case, where there was a Bible monument that had been erected in front of the Harris County Courthouse for the express purpose of promulgating Christianity. And this conservative Republican judge, Sim Lake, decided that that was unconstitutional because you had to pass by that Bible, which was erected for the purpose of promulgating Christianity during the Cold War era. And so he held that that sort of Bible monument was using the power of the state and taxes to promulgate religious views, and that ended up being prohibited, affirmed by a divided Fifth Circuit, cert denied in the U.S. Supreme Court. So these issues are often factually intensive, but they're always fascinating. I'm going to talk about a little about this history of separation of church and state with a few slides that contains some of the research I presented to the Texas State Historical Association on behalf of the Texas Supreme Court Historical Society. And so we'll ask, is there a war on Christmas right now? And beyond that issue, we'll look at, is the issue of separation of church and state, is this some modern myth of the Warren Court that they just made up in the liberal, beyond control 1960s? There are some members of the Republican Party who put a proposition, ballot platform into the Texas Republican Party's platform that refers to the myth of separation of church and state, and that they seek to repudiate this myth. I only offer this not for political reasons, but just as an example of how this sort of matter is the subject of public conversation. We'll look in the slides ahead and ask if separation of church and state was in fact a myth. So we begin by noting the fact that America began with religious warfare. There were sort of massacres at a time when the founders of America's colonies believed, as Louis XIV put it, in une foi, une loi, un roi, or one faith, one law, one king. Complete unification of church and state. And that was the way things were when Spain originally created the colony of Texas. Of course, although one of the very first founders, one of the first Spaniards to walk across Texas, Cabeza de Vaca, his Moorish servant, having been Islamic, was probably the first Muslim to actually walk across Texas and to begin about Galveston Bay and end up in Acapulco, which to my mind is always a good progression, to begin in Texas and end in Acapulco. And then Cabeza de Vaca wrote the whole story in his Relación, which you can find down in the J.P. Bryan Museum in Galveston, an original copy a good reason to go to Galveston, as opposed to Cabeza de Vacas, which was to shipwreck there. So learn from the past and learn history there. The Spanish Empire had the Inquisition and believed in unity of church and state, and thus those were several of the reasons mentioned in the Texas Declaration of Independence and the consultation coming out of that alcalde, Stephen F. Austin's San Felipe de Austin Colony, when it was the center of Texas in 1835. So these things play on. In 1565, the French Huguenots or Protestants built a church, the first Protestant church in North America, and a settlement at what is now Jacksonville, and a Spanish conquistador by the name of Pedro Menendez de Avilas was tasked by King Philip II with the task of exterminating this settlement, which he did with great gusto, including the murder of some 300 French Huguenot prisoners of war, and he erected a sign to commemorate that at a place called Matanzas, short of just a few miles south of St. Augustine, which means massacre. So he gloried in what he had done, killing these French Huguenots, and the placard he put up said, not because they were Frenchmen, but because they were heretics. Then a group of French came back and took a fort there of those Spaniards who had been involved in that massacre and slaughtered all of them and left a placard there saying not because they were Spaniards or Catholics, but because they were murderers. So that was how American history starts in 1565. And the First Amendment, I would submit to you, is the way we have overcome those sorts of religious conflicts and wars which characterized early America as well as Europe. The time when Queen Elizabeth was establishing the virgin land of Virginia and fighting off King Philip II's, yep, same one, Philip II's Armada in 1588. That's when English people were beginning to settle in the Netherlands to enjoy freedom of religion under the Treaty of Utrecht, which allowed people who are Catholics and Jews to worship in the privacy of their own homes. It was the beginning of religious toleration. That religious toleration spread across the North Sea over into Suffolk and to London, and began that sort of belief in religious toleration and the separation of church and state that the Pilgrims followed with the English Pilgrim Separatism, because actually if you ask, what were the Mayflower Pilgrims? What did they call themselves? Well, Bradford said they called themselves Pilgrims because they went looking for a new land, but he also referred to them, they all referred to themselves as separatists because they believed that the Anglican Church that King Henry VIII had founded was so inherently corrupt it could never be reformed, and therefore they would separate from it. Why would they think that a church founded by an indisputable serial killer, at least if you ask Anne Boleyn, was corrupt? I don't know. But that's what they believed, and that's why they sailed the ocean blue in 1620 to come over to Plymouth. So the Mayflower Pilgrims separated, and they adhered to the Geneva Bible, which had been written by John Calvin and the Calvinists in Geneva. But that Bible used the term Serenos and interpreted that literally as tyrant for the word king. Not surprisingly, King James I preferred a different translation. And as a result of that, we have the King James Bible that he came out with in 1611. But that's not the only Bible that's influenced American history, because the Pilgrims and the Massachusetts Bay Puritans brought their Geneva Bibles. And so at the very beginning, we have a separation of church and state issue that is at the heart of Plymouth Colony and in disputes between the New England Puritans and Pilgrims and their brethren back in England. James I, make sure that the King James Bible goes everywhere, but if you go to Pilgrim Hall, you'll find that the original Bibles of Governor William Bradford and the other leading pilgrims are all Geneva Bibles. So, in 1619, we have the Anglicans in control of Virginia. We have the first slavery here. We have the first General Assembly. And we have the Anglican Church in full power, no separation of church and state. 1608, just a few years earlier, the Pilgrims land up in Leiden. They imbibe the tolerance, the tolerantia of the Netherlands, and they bring that with them on the Pilgrims. They bring that with them after doing things like having state-organized marriages in Leiden's Stadthuis. That's the beginning, way, way back in the beginning of what becomes the Obergefell decision that says that the state decides who will be married and who can marry each other separate and apart from what religious traditions dictate. Well, that begins with the Pilgrims who come over here. Here, for example, is Isaac Allerton's Geneva Bible that I have personally reviewed and written about because it reflects the mindset of one of those original Pilgrims who chose to leave England so he wouldn't have to worship using the King James Bible, among other things. He would have his choice of Bibles as a separatist. I date separation of church and state through Plymouth Colony. Think about that at Thanksgiving. That's where it begins. So they come over in 1620. They create a Mayflower Compact, this country's first written constitution, which is more than anything else a secular instrument. While acknowledging God, it is people here not accepting James I's idea of the divine right of divinely appointed kings, but instead opting to elect their own minister, and more importantly, their own governor and his assistants. That's the first time in North American history where the actual people who live in a colony elect their own leaders through the Mayflower Compact. That is also a beginning of separation of church and state here. But with respect to a war on Christmas, the real war on Christmas was the one waged by here Governor William Bradford and John Winthrop and other leaders of Puritan background who believed that, who here were telling the people, William Bradford telling the colonists, you have to work on Christmas Day. And they would say, why? He said, well, because it's a popish superstition. Nothing in the Bible commands or says that Jesus Christ was born on December 25th. Where did we get that date? We got that date from Rome. After all, the Bible talks about the shepherds being out in their fields with sheep. That's in the spring, it's not in December. December 25th was instead the licentious Roman pagan holiday of Saturnalia, where servants would dress up as masters and masters would dress up as servants, and people would play reverse gender roles. Heaven forbid. And so Christmas was a popish holiday, and it was banned by the New England Puritans like John Winthrop, who came over in 1630 to create that city on a hill known as Massachusetts Bay, and to create the New England concept of religious freedom. I dare take upon me to be the herald of New England so far as to proclaim to the world in the name of our colony that all non-Puritans, familists, antinomians, Anabaptists, and other enthusiasts shall have freedom to keep away from us. Love it or leave it, accept our ideas of Calvinist religious freedom or get out. And so Puritan religion in New England, you had to be a church member to vote. There was no separation of church and state, no toleration for Baptists, Catholics, Anglicans, familists, or Turks. The war on Christmas, no Christmas celebrations in Plymouth or Puritan Boston. And that's where Roger Williams comes in, a Cambridge minister who comes to Hull and to Plymouth in 1631, and he teaches, after going to the Bay Colony, that there should be a separation of church and state, that the state does not have the power to enforce conscience. And he is also at that confluence between law and religion because he had been the law clerk to Sir Edward Coke, who was the chief Attorney General of Britain under Elizabeth, and also filed the Petition of Right in Parliament to strip Charles I of his divine right pretensions and to replace the law in England with a rule of law that was not bowing down before a king who said that he was the one and only authorized voice of God. Exiled from the Bay Colony, in 1635, Roger Williams founds the first Baptist church in America in Rhode Island and Providence plantations, and on his way back to Cromwell's, to an England torn by civil war and religious strife in 1644, gets published The Bloody Tenet of Persecution in London, in which he takes the proposition that all civil states, essentially civil and therefore not judges, governors, or defenders of the spiritual or Christian, God requireth not a uniformity of religion to be enacted and enforced in any civil state, and therefore leads Rhode Island, referred to by those Puritan ministers as Rogues Island, into a critical analysis of the idea of combining state and church, saying that the state and politics will always corrupt any church that aligns itself with temporal power. Thomas Jefferson would reverse that to say that the church will always corrupt any state that brings ministers into the government. But both of them would have agreed that when you combine church and state, you have the basis for tyranny and using the power of the state to deprive people of their rights and liberties on the basis of conscience. So Roger Williams actually gets a charter of Rhode Island and Providence plantation that is the beginning of separation of church and state in America. And this is later memorialized 10 years later by Charles I's son, Charles II, in the Charter of Rhode Island in 1663. And it says in pertinent part, "No person shall be in any wise molested, punished, disquieted, or called in person for any difference in opinion in matters of religion. All may freely and fully have and enjoy his own judgment and consciences." So what I'm suggesting to you is Rhode Island led the way forward and paved the path that would lead to our First Amendment by saying that there is one realm for church and one realm for state, and liberty requires that the two be separated. And it was written down and made a part of a charter of a self-governing people for the first time in 1653, for the first time in the world. And that begins right here in America, and that's part of the tradition we can be proud of. Now, the Puritan War on Christmas continued. London in 1647, Cromwell and the army come into power, and they enact a law abolishing the observance of Christmas. And then down in Massachusetts Bay in Boston, the Puritans have free reign, and they impose a 50-shilling fine on anyone observing a popish Christmas. But of course, they celebrate every Guy Fawkes Day, every November 2nd, by, casting a penny for the guy and burning effigies of the Pope. So, that was the sort of tradition in New England, but not in that rogues colony of Rhode Island, where Jews moved there in 1658 and find full acceptance and full toleration. And so you can go down to Truro Congregation in Newport and find this synagogue that goes back to the 1650s, a beautiful building, and one celebrated by the Jewish historian Simon Schama, who said it is no accident then that Jews first found refuge in Newport, Rhode Island, nor was it any chance that almost exactly 220 years later, George Washington, campaigning for the adoption of the First Amendment to the Constitution, seeking its ratification in Rhode Island, repeated the words of Moses Seixas, the leader of this congregation, that the U.S. was a place that gave no bigotry, to bigotry no sanction, to persecution no assistance. And he said that here in America, the Jew will be free to have his glass of wine and his olive tree and enjoy the freedoms that have been denied the Jew elsewhere in Europe. And that too is a part of the separation of church and state that culminates there in the ratification by the states of the First Amendment as part of our Bill of Rights that says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise therefore. And in Article 6, Clause 3 of the Constitution, stating the Constitution bars requirements of religious tests for governmental office, saying no religious test shall ever be required as a qualification in any office or public trust under the United States. And that example led the states that had established churches in the next 2 decades to end their establishments of state-sponsored religion. The most fascinating thing to look at, and this is where I'm going to close early on these issues of separation of church and state, is on the 1797 war against terror, America's first war against terror, against the Barbary Pirates. And so here we actually see some of the fighting depicted here between the Barbary Pirates of essentially Tunisia, Algeria, and Morocco against U.S. Marines and Navy in that period of time. What we have was something that I'd encourage you to look up today, Treaty number 122, still in the top 200 treaties of the United States of America, the Treaty of Tripoli. It ended that first Barbary Pirates War, and it contains a paragraph we'll look at in a moment that states that the U.S. is not a Christian nation by law, but one founded on universal principles of law. And as it states in Article 11, as the government of the United States of America is not in any sense founded on the Christian religion, as it has in itself no character of enmity against the laws, religion, or tranquility of Muslims, and as the said states never entered into any war or act of hostility against any Mohammedan nation, it is declared by the parties that no pretext arising from religious opinions shall ever produce an interruption of the harmony existing between the two countries. Now think about that. The important language, as the government of the United States of America is not in any sense founded on the Christian religion. So what was it founded on? It was founded on the concept of law. A new creation. The unique aspect of the United States was that law would govern our relations, not an established church, not that Louis XIV concept of une foi, une loi, un roi, one faith, one king, one law, but instead a place where faiths could blossom and bloom of all different varieties without either being sanctioned or supported by the federal government or later by the states under the 14th Amendment. That's what makes America unique. Now think about what that means. 1797, the ambassadors who negotiated that contract did so on behalf of the United States, having been sent to the Barbary States by our first president, George Washington. Signed on November 4th, 1796 in Tripoli, and in 1797 in Algiers. President John Adams, a Congregationalist from a state that still had the established state church, Congregationalism, signed it in 1797. The 5th U.S. Congress ratified it unanimously, making it the law of the United States on June 10th, 1797. I would submit that there is no better proof that America is a nation under law and is not by character or by constitution, a nation that is exclusively Christian, but is instead a law-bound nation that has welcomed and encouraged and allowed a wide variety of religious faiths, of Christian faiths, to abound here. Thomas Jefferson felt the same way, because when the Danbury Baptist congregation up in Massachusetts wrote to him complaining of being discriminated there, he wrote his famous Danbury Baptist Association letter of October 7th, 1801, stating, "Our sentiments are uniformly on the side of religious liberty, that religion is at all times and places a matter between God and individuals, that no man ought to suffer in name, person, or effects on account of his religious opinions. But, sir, our Constitution is not specific," had been the statement. And he says, "I contemplate with sovereign reverence that act of the whole American people which declared that their legislature, Congress, should make no law respecting an establishment of religion or prohibiting the free exercise, thus building a wall of separation between church and state." And then James Madison, the father of the Constitution, came in a few years later when he became president stated that we are teaching the world the great truth that governments do better without kings and nobles than with them. The merit will be doubled by the other lesson that religion flourishes in greater purity without than with the aid of government. And as he later stated in one of his letters, if Christianity could survive the worst massacres of the Caesars and their persecutions for centuries, it does not need the support of the government to survive in a nation that protects people's rights to be Christians. So for these reasons, I submit that church and state separation is not a liberal myth of the Warren Court, something made up by judges with an intent to isolate Christians or to wage a war on Christmas, but instead that this nation should celebrate how it overcame those religious differences, those wars and massacres that were there at the foundation of American civilization down in Florida, in that little distance between St. Augustine and Jacksonville, Florida. But instead, we as Americans ought to proudly recognize that the separation of church and state is no myth, but is at the core of the American experience and something that we as lawyers and as judges ought to be proud of. And when someone speaks of separation of church and state being a modern myth, the response is to say, that is a legal fiction, or that is a law, that is a falsehood, or, if we're brutally blunt, that's a lie. Because separation of church and state is at the very heart of the American democratic experience, and I'm happy to be a part of this group discussing issues of church and state and religion and our society and civilization here today. Thank you for hearing me out.
Okay, obviously we went a little over, but everybody's still here, and it's now time for you to ask the panel any questions you may have. Anyone have any questions? Yes, ma'am. Just speak loudly, please.
Yes, this is for Mr. Sasser. In your New York case, the rule or the attempted legislation of the amount of space one could devote to one's religious library, was that targeted strictly at the Jews or to all religions within that jurisdiction?
Well, because the town was founded as its stated purpose to exclude the Orthodox Jewish community, and they've spent the past 30 years gerrymandering their laws to try to exclude the Orthodox Jewish community, and the various politicians have been running on the platform of keep Airmont. There is no other religious group to which it would apply, and they certainly have not applied it to anybody else, and we have some examples of other just regular Bible studies and stuff that occur that they haven't applied it to, or other home-based group meetings. So they're specifically written to target the Orthodox Jewish community. Now they've learned over the years to stop referring to in-home synagogues in their ordinance. They've gotten more sophisticated in their discrimination, but it's not because they've suddenly become enlightened. Well, one thing I wanted to ask a question because I thought it was interesting. What do you make of in the Capitol Rotunda, the U.S. Capitol? There's 8 gigantic portraits. They're about 20 feet wide and 10 feet tall, put up in the 1840s and 50s. 4 of them are Revolutionary War battles, but the other 4, one is the baptism of Pocahontas. The other one is of the Pilgrims holding the Geneva Bible. The other one is a blessing of the Mississippi River by a monk in DeSoto there, discovering the river, but you see the monk and raising up a cross or whatever. Well, what do you make of that?
I make of that a recognition of the fabric of American history that includes, amongst other things, French and Spanish colonies where there was no separation of church and state, where in Virginia, one of the steps forward that ended the bloodiest of the wars between the Powhatan Indians and the original English settlements was the marriage of Pocahontas to John Rolfe, not John Smith, but John Rolfe, the tobacco producer, which put Virginia, on a state to go forward with, a peaceful background. So that reflects that, in fact, America was a nation where Christianity was an important part of the cultural history and the background. On the other hand, one could look at that and say, paintings on the rotunda are not constitutional documents, and that when we examine the constitutional issues of separation of church and state, we look not to paintings painted some 50 years after the Bill of Rights was enacted, but instead to the Federalist Papers and to the pronouncements of John Adams, Thomas Jefferson, James Madison, and most particularly to that Treaty of Tripoli, because it's fact that it was universally and unanimously affirmed by the Senate. Those were the people who fought the British, who faced British bayonets and a British war, and they were the ones who were not doing that. I don't think they were cowards. I think that they were people who faced up to British steel and gunpowder, and they made that pronouncement that the Treaty of Tripoli was appropriate and ratified it because they recognized that their new creation, the United States of America, was a nation under law and not a nation that had an established religion or was in fact a Christian nation.
But you think it's okay to have those paintings?
I think it's perfectly fine. They comment on the culture of America, mainly in the 19th century, but they reflect the religious traditions that have been a part of American culture, which no one should deny.
Good question. Okay, folks, who else has a question, comment, observation, critique? These gentlemen will be here.
I just
Mr.
want to thank y'all. This is an interesting program, and I like that you can bring different aspects of religion, like, for example, how some of the Jewish traditions became incorporated into our law, as well as Muslims and Christians. So this was a very fascinating program, and I thank y'all for being here.
Okay.
Great.